Yes.
Good evening, everyone. Welcome to AOR lecture series for AOR aspirants appearing for the exam this year. We are truly honored to have with us today a distinguished guest speaker, Senior Advocate Sonia Mathur ma'am, who will be delivering lecture on one of the papers, Ethics. Before we begin the lecture, I would like to take a moment to introduce our esteemed speaker. Sonia Mathur ma'am is a senior advocate designated by Delhi High Court in year 2017 with over 3 decades of experience in law. In addition to her work before the Supreme Court of India and various high courts, she has represented clients across specialized forums such as income tax tribunals, competition law tribunals, and consumer protection forums. She served as a special prosecutor for cases related to the 2G spectrum scam appearing before trial court, high court, and Honorable Supreme Court of India. She was also a standing counsel for CBI and the senior standing counsel for Income Tax Department before Delhi High Court. Sonia Mathur ma'am holds a master's degree in labor laws from the University of Rajasthan and another master's degree in taxation from the Washington College of Law. She is frequently invited as a resource person at a National Judicial Academy in Bhopal, where she addresses special judges of the CBI, judges presiding over the motor accident claim tribunals, and visiting judges from other countries. 4 cases argued by her as CBI lawyer was included in compilation prepared by Delhi High Court in year 2011 and 12, which highlighted the court's contribution to the development of law. She was also part of an editorial team for the 11th edition of Kanga and Palkiwala on income tax. Additionally, she has been appointed as amicus curiae in death penalty cases by the Honorable Supreme Court of India. Over to you, ma'am. Ma'am,
you're on mute. It's unmute, yeah.
Yes, hi. Thanks, Reena. Good evening, everyone. And huge compliment to SCAORA for doing these lectures. So the topic assigned to me today is the paper 3, which is the advocacy and professional ethics. Now, there's a notice of 9th of April 2025, where there are certain topics suggested for this paper. Now, on the basis of these suggested topics, I have sort of broken up the entire proposed syllabus into 20 subtopics. I hope I'm able to cover most of these suggested topics, but let's just see. I'll try and cover as much as I can. Now, professional ethics, it is considered to be the foundational bedrock of the legal profession. Now, so far as the core ethical values are concerned, which are honesty, confidentiality, diligence, independence, and loyalty, these are the values which are globally recognized. But their interpretation and also the enforcement, it often varies in each country on the basis of the legal traditions and institutional frameworks, and also to a certain extent cultural norms. So let's just start with the statutory provisions which govern the concept of professional conduct. Now, first is Chapter 5 of the Advocates Act of 1961. Now, this chapter predominantly provides the statutory framework for the professional rights, duties, and responsibilities of the advocates. Now, particularly the relevant sections would be section 35 to 44. Now, section 35 talks about misconduct, which enables disciplinary action by the competent authority, which includes reprimand, suspension, and also removal from the bar. Then section 36 and 36B. Now, these sections provide for BCI's power to transfer cases, but also prescribe for proceedings to be completed within 1 year. Section 37 provides for appeals to the Bar Council of India. Section 38 provides for further appeals to the Supreme Court. And Section 42 provides that disciplinary committees under the BCI would have the powers that of a civil court. And Section 39 to 44 prescribed for review, stay, and enforcement of disciplinary orders. Now, this next statute, which governs the professional conduct, would be Chapter 2 of Part 6 of Bar Council of India rules. Now, this chapter broadly outlines the standards of professional conducts and etiquettes expected of an advocate under the different sections. Now, Section 1 of this deals with the duty to the court. Section 2, duty to the client. Section 3 is duty to the opponent. Section 4 is duty to colleagues. And Section 4A is BCI Advocates Welfare Fund. And Section 5 is duty in imparting legal training. Section 6 is duty to render legal aid. Section 7 is restriction on employment. Then comes Order 4 of the Supreme Court Rules 2013. Now, Order 4 delineates the special responsibilities and additional ethical obligations of advocate on record. Although some duties which are prescribed here do overlap with those under the BCI rules, Order 4 imposes stricter standards and procedural obligations which are unique to the Supreme Court practice. Now, misconduct under the Advocates Act 1961 is defined under Section 35, subsection 1. Now, it says disciplinary action for professional or other misconduct, which therefore includes ethical lapses, dishonesty, improper behavior in and outside the court as well. Section 24A bars enrollment of persons convicted of serious crimes. However, the strict provision here is balanced by a proviso which allows Bar Council a discretion after 2 years. Now, when it comes to interpreting the term professional or other misconduct, which is prescribed under Section 35(1), there are certain judicial precedent which we can refer to. I'll just go through some of them. One is Noratanmal Chaurasia versus M.R. Murli. Choraria versus M.R. Murli. This is 2004, Volume 5, SCC 689. And this says that allegations which are even outside the professional scope do not always amount to professional misconduct. But there are cases where even the professional misconduct outside the professional scope has been taken to be misconduct. We'll just refer to them. Then the next is Shambhuram Yadav versus Hanuman Das Khatri, which is 2001, Volume 6, SCC, page 1. Now, in this case, while examining professional misconduct under Section 35 of the Advocates Act, it was held that to communicate to a client that a particular judge is open to bribery and to suggest that the client should part with some money which has to be passed to a judge is a serious misconduct. In this case, the court acknowledged duties of members of legal profession to the society at large. And it held that they don't owe obligation only to the court, but the obligation is to the society at large. So therefore, scope of professional misconduct was slightly enlarged, and said that bribery allegations leading to permanent disbarment cannot be held to be without jurisdiction. And then the next is State of Punjab versus Ram Singh, 1992, Volume 4, SCC, page 54. This was in the context of service law. Now here, it was, in fact, the scope, I would say, was further enlarged because it said that misconduct, it says, though not capable of precise definition, but on reflection receives its connotation from the context, the delinquency in its performance, and its effect on the discipline and nature of the duty. So therefore, it depends what is the nature of the duty and to what extent is the delinquency. So the misconduct term was interpreted widely, and it was held to include even non-professional behavior. This was a case of police disciplinary authority. Now, certain cases, judicial precedent on the aspect of professional misconduct. Now, breach, it's different headings that I've broken it into. Breach of client confidentiality and trust. The first judgment that I wish to refer to is P.J. Ratnam versus Kanikaram. This is 1963 judgment. And in this case, the court held that misconduct must affect the dignity of the profession. In this case, advocate was suspended for 5 years on the allegations of misappropriation of the money which was belonging to the client. And not only that the advocate failed to pay, but also took a false defense of payment. So court viewed it very seriously and held that the suspension for 5 years was a very lenient sentence, whereas it even if it was a permanent striking off from the role, that would have been fair. However, it was not enhanced. And then V.C. Rangadurai versus D. Gopalan, 1979, 1 SCC 308. It said that falsely claiming to have filed a case and misrepresenting facts to the client also amounts to misconduct. Then P.D. Khandekar versus Bar Council of Maharashtra, 1984, 2 SCC 556. In this case, it was held that the professional negligence without moral delinquency does not qualify as misconduct. So therefore, the standard of proof which lies between the civil and criminal, the same threshold has to be adopted with regard to the standard of proof. So therefore, negligence by itself without moral delinquency would not necessarily qualify as misconduct. Then Harish Chandra Singh versus S.N. Tripathi, 1997, 9 SCC 694. His fraudulent use of client authorization for personal gain constitutes gross misconduct. Then D.S. Dalal versus SBI, 1993, supplement 3 SCC 557, where it was held that misappropriation of client fee and failure to inform about returned suit led to disbarment. It was a case of permanent disbarment. And then John D. Souza versus Edward Annie, 1994, 2 SCC 64. It said that retention of client's original will without consent amounts to professional misconduct. Then the second aspect of our profession is dereliction of duty to the court. So therefore, it is duty to the client and then duty to the court. The first case is Lieutenant Colonel S.J. Chaudhary versus State, 1984, 1 SCC 722. It was held that non-compliance with a day-to-day trial order is a violation of court duty. Then N.G. Dastani versus Shrikant Shivde, 2001, 6 SCC 135, says that misuse of adjournments and false excuses constitute abuse of process and ethical misconduct. Then some more judgments with regard to acting without client authority. I'll just give you the citations. Bairam Pestanji Gariwala versus Union Bank. This was 1992, 1 SCC 31. And then Narayan Pandey versus Pannalal Pandey, 2013, 11 SCC 435. It says that filing of forged wakalatnama and unauthorized compromises warrant suspension from the role. However, in CBI versus K. Narayan Rao, 2012, 9 SCC 512, it said that erroneous legal advice, the earlier also we referred to one judgment where the same thing had been held, that erroneous legal advice by itself without any component of criminal conspiracy is not really deemed misconduct. Then there are certain instances where fee-related misconduct has been noted by the court, where the clients, where the court fee was misappropriated and it was held to be professional misconduct. This is L.C. Goyal versus Suresh Joshi, 1999, 3 SCC 376. Then on the same lines is Harish Chandra Tiwari versus Baiju, 2002, 2 SCC 67, where the advocate had misappropriated the client's money which was received by him in a land acquisition case and filed a forged affidavit. He was held to be guilty of grave misconduct. One more judgment, which we can just sort of quickly see here, is R.D. Saxena versus Balram Prasad Sharma, 2007 SCC 264. In this case, Supreme Court held that the advocate have no lien over litigation papers and must return client files regardless of fee dispute. The court emphasized that the cause of justice outweighs fee recovery, and client's right to legal representation is protected under Article 22 of the Constitution and Order 3, Rule 4 of the Civil Procedure Code. Then criminal misconduct and violence. In case of Hikmat Ali Khan versus Ishwar Prasad Arya, this is 1997, 3 SCC 131, it was held that physical assault in court premises and forged documents led to disbarment. So this was also held to be a case of misconduct. Then contempt of court and professional misconduct. There is a lot of overlapping in these two concepts. So Advocates Act 1961 is dealing with the professional misconduct, whereas Contempt of Court Act 1971 deals with contempt of court. So with regard to professional misconduct, the jurisdiction lies with the bar councils, and with contempt of court, the jurisdiction lies with the courts. Now, punishment for professional misconduct can be reprimand, suspension, removal from role. Pardon me. And the punishment for contempt of court is fine, imprisonment, and restrictions on court. The nature of proceedings is disciplinary in case of professional misconduct and quasi-criminal in case of contempt of court. Now, just a couple of important precedents. One is In Re Vinay Mishra. This is 1995 to SCC 584. In this case, the advocate threatened a judge with transfer or impeachment. So Supreme Court held that it could suspend license for contempt under Article 129 and 142, and the license was suspended for 3 years. However, in the case of SCBA versus Union of India, which was 1998 for SCC 409, Vinay Mishra was partially overruled. And the court analyzed Articles 129, 142, and 144. And it held the jurisdiction of Supreme Court to punish an advocate for contempt of court is different from the jurisdiction to punish an advocate for professional misconduct. Now, former is conferred on the Supreme Court by Article 129, read with Article 142, while the latter is exclusively conferred on the authority such as State Bar Council or the Bar Council of India created under the Advocates Act. So it was held that Supreme Court can't punish for misconduct under the Advocates Act via Article 142. Only bar councils can suspend license, but Supreme Court can certainly act if the bar councils fail to act. Then R.K. Anand versus Registrar Delhi High Court. This is 2009, 8 SCC 106. In this case, the advocate was caught influencing witnesses in that famous BMW case. So Supreme Court upheld the High Court's power to bar entry as distinct from professional misconduct. Then Mahipal Singh Rana versus State of UP, 2016, 8 SCC 335. In this case, the advocate was jailed for threatening a judge. And it was held that the advocate could not have appeared in the court unless the contempt is purged, even if the license is not suspended. R. Muthukrishnan versus Registrar General, Madras High Court, 2019, 16 SCC 407. In this case, Supreme Court had struck down Madras High Court rules for debarment without using contempt power. It held that only the Bar Council can take disciplinary action, not High Court via administrative routes. So there is clear demarcation of jurisdiction in terms of professional misconduct and contempt. Then Chandra Shashi versus Anil Kumar Verma, 1995, 1 SCC 421. The court said that anyone who takes recourse to fraud deflects the court of judicial proceedings, and the same amounts to interference with administration of justice. Now, a 3-judge bench in Mohit Chaudhary advocate, this was 2017-16 SCC, page 78, said that the court recognized the duties of an advocate to put his best case for his litigant before the court. But however, this does not absolve him of the responsibility as an officer of the court. And court referred to the dual responsibility that an advocate bears, which is one to the court and one to the client. And the court specifically refers to the rights of an advocate on record in the Supreme Court. And it held that it is not an automatic right to practice as an advocate on record. It's not an automatic right coming from the enrollment at the bar, and something more has to be done. The rigors of an examination have to be gone through, which tests the advocate not only on his legal ability of drafting and knowledge of law, but also on ethical practices. It is only after going through the rigorous exercise that an advocate is enlisted as an advocate on record, giving him the right to act and file pleadings before the Supreme Court in accordance with the Supreme Court rules of 2013. So there was a specific reference to the advocate on records in this case. Then Sonia Chaurasia versus Director of Enforcement, 2024, 6 SCC 201. These are some of the latest cases which you may want to have a look at. Then Bhagwan Singh versus State of UP. This is 2024 SCC Online, SC 2314. In this case, Supreme Court had issued certain directions for strict compliance of the Supreme Court rules of 2013, which are framed by the Supreme Court in exercise of its powers under Article 145 of the Constitution, for regulating the practice and procedure of the court to be followed by the persons who are practicing in Supreme Court. Then we've had a recent case, although this matter is still sub judice, but you may want to have a look at it because merits are, of course, pending before the court, but they're legal principles. This is SLP Criminal Diary number 55057 of 2024. This was, the referral order was passed on 17th of April 2025, N. Ishwaranathan versus State, represented by the Deputy Superintendent. In this case, there was divergence of opinion, so now it has to go before the Chief Justice. Then there is another case which is Criminal Appeal number 1318 of 2025. This was decided on 27th of March 2025. And the cause title is Ramesh Kumaran versus State through the Inspector of Police. This is in 2024 SCC Online, SC 4938. This was a judgment by Justice Abhay Oak and Justice Ujjwal Bhuyan. This was a case where the dispute was between two lawyers, and one had threatened the court with suicide. So the conduct was definitely held to be contemptuous by the court, but ultimately his apology was accepted. He had rendered unconditional apology, which was accepted, and the FIR between the lawyers was quashed in exercise of jurisdiction under Article 142 by the court. So now, role of lawyers in upholding public trust. Now, public trust in the judicial system stems from bar and the bench both. So when it comes to the bench, it is impartiality and independence of judges, which is the bedrock of the public trust in judicial system. Now, those are reflected in their constitutional oath under Schedule 3. So far as the lawyers are concerned, it is only the ethical and responsible lawyering as lawyers are officers of the court. So the public trust can be built by the bar and the bench both by bench, maintaining the impartiality and independence of the judges, and by the bar, by following ethical and responsible principles of lawyering. Now, what are the challenges in this regard to the public trust? Now, first challenge is corruption and misconduct. Now, these can be addressed through various means, but some of them can be strengthening laws and regulations to prevent corruption, improving transparency and accountability in the government, ensuring that officers are held accountable for misconduct. Now, the other hurdle, apart from corruption and misconduct, would be lack of transparency and accountability. Now, these can be addressed through some of the means can be improving access to information, strengthening oversight bodies, ensuring that officials are held accountable for their actions. And the third aspect is ineffective or biased communication. Ineffective or biased communication can also be taken care of partially by improving communication channels, providing accurate and unbiased information, and ensuring that communication is accessible to all citizens. And of course, Supreme Court is following it to a huge extent. Now, there is also public trust doctrine. Now, this doctrine guarantees the protection of natural resources. Article 21 of the Constitution guarantees the right to life, which means the right to a clean and healthy environment, which is also a fundamental right. And if this right is encroached, then the citizen has a right to approach the court to enforce this right. Article 51, capital A, states that it is also duty of the citizens to see that the natural resources are not overused as they cannot be replaced. The other relevant articles are Article 48A, which made a way through Article 21 by including the right to clean environment under the right to life. And then it's Article 39, which is Directive Principles of State Policy, which state about proper distribution of resources. The relevant judgment on the doctrine of public trust are MC Mehta versus Kamalnath. This is 1997, 1 SCC 388. Now, public trust doctrine was first alluded to in India through this landmark case. This case is also known as the Span Motel case. In this case, there was a PIL which was filed and it challenged the Minister of Environment, the then Minister of Environment, who had allowed the Span Motel company to construct a hotel near the mouth of River Beas in Himachal Pradesh, and also allowed the company to change the course of the river for the construction by blasting the riverbed. So the Supreme Court in this case had held that public trust is more like an order for the state to use the public property for public purposes. The second judgment worth noticing is MI Builders Private Limited versus Radhesham Sahu. This is 1999, 6 SCC 532. In this case, the court had ordered the public trust doctrine under the right to life and stopped the construction of the shopping complex in place of a public garden, stating that the garden was a public resource. The court further stated that allowing the construction would deprive the public of the quality of life, as stated under Article 21 of the Constitution. Third judgment is Shailesh R. Shah versus State of Gujarat. This is Gujarat High Court judgment 2002, 3 GLR, page 447. In this judgment, the obligation of the state was actually portrayed in a positive manner, positive nature. In this case, the court had stated that the state holds all the resources like the lake, pond, natural gases, and wetland. And as the state is held as the trustee, it is the duty of the state to maintain and protect them for public use. This was held to be positive duty of the state to prevent the resources and the environment from degradation and safeguard them from extinction. So it was held to be a positive duty of the state to preserve the resources. Then Thiru Majra Singh versus Indian Oil Corporation, 1998, SCC Online, JNK, page 44. In this case, the suit was filed against location of an LPG plant, which was used for filling up cylinders. So the petitioner was of the view that it was located near the village in Jammu district and could be harmful for the health of the people staying in that locality. The High Court observed that this public trust doctrine is an integral part of Article 21 of our Constitution, and the state is obliged to protect and preserve the lakes, forest, wildlife, and environment. The court further held that the people's notion that they have the right to anticipate particular lands to retain their originality in making its way into the law of the land. Then Jitendra Singh versus Ministry of Environment. This was 2020, volume 20, SCC 581. This case was also filed against the allotment of water bodies to private industrialists, and court took a very serious view of this. Now, moving on to the next topic, subtopic, which is duties to the court versus independence of the bar. Now, duties to the court. As officers of the court, the lawyers must uphold truth, fairness, and judicial decorum, avoid misleading the court or obstructing justice, maintain professionalism and candor in proceedings. Bar independence it's also equally important, and how this could be maintained is that bar need to be free from judicial or executive pressure, able to represent clients fearlessly, including in sensitive and unpopular cases also. And they're governed by the Bar Council, not governed by the judiciary, to ensure professional autonomy. Now, the balancing act how would you maintain a balance between the two? So the lawyer must advocate assertively without becoming subservient or disruptive. Ethical advocacy requires balancing clients' interest with duty to the court, preserving both integrity and independence. Continuing duty of confidentiality. Even after the client-advocate relationship ends, confidentiality remains. There are judgments which confirm that lawyers must never disclose privileged information, reinforcing long-term trust in the profession. Now, the next subtopic is strikes. Strikes by advocates. Strikes are illegal. Lawyers' strike and court boycotts are illegal, except in rare cases involving threats to the dignity or independence of the judiciary. And even then, it is limited to 1 day with prior consultation to the Chief Justice or District Judge. It amounts to professional misconduct. Why? Because not appearing in a court after accepting a brief would constitute professional misconduct. It undermines the administration of justice and also the client's interest. Now, advocate has a dual duty, as we already talked about it, to their clients and also to the court. So the strike violates both by obstructing justice and breaching professional responsibility. Now, there are certain alternative protest methods. Supreme Court, in the case of Common Cause versus Union of India, this is 2006-9 SCC 304, it encouraged non-disruptive protest, such as wearing black armbands, passing resolutions, or symbolic observances without disrupting court proceedings. Now, what are the consequences of these violations? Consequences are contempt of court, debarment from court appearances, and suspension of license by the Bar Council. Now, certain critical judgments in this regard are Mahavir Prasad Singh versus Jack's Aviation, 1999, 1 SCC, page 37, where advocates boycotted a judge's court following an unfavorable order. So the Supreme Court condemned such conduct, and It held that retaining a brief and refusing to appear is unprofessional and constitutes browbeating. Because these advocates who disagree with the judge must return the brief and not disrupt proceedings. Common Cause versus Union of India, 2006-9 SCC 304. While the court avoided a broad ruling on lawyer strikes due to a consensus between the parties, it directed that individual lawyers must not be hindered from appearing, and alternative forms of protest were encouraged instead of strikes. Harishupal versus Union of India, 2003 to SCC, page 45. This is a landmark decision where it was held that lawyer strikes are illegal with only a narrow exception for one-day protests concerning the dignity or independence of the judiciary, and only with prior consultation with the Chief Justice or District Judge. And next in this line is Hussain versus Union of India, 2017, 5 SCC 702. Court emphasized the right to a speedy trial and directed high courts to monitor and act against strikes, reinforcing the Harishupal precedent, which we just mentioned, to prevent delay in bail and criminal proceedings. Because especially in case of criminal trials, they are the biggest casualty when the strikes take place. Krishnakant Tamrakar versus State of MP, 2018-17 SCC, page 27. In this case, the court reiterated that every strike causes irreversible harm and amounts to contempt of court. District Bar Association, Dehradun versus Ishwar Chandelier, 2020, 17 SCC 672. This was a case of permanent Saturday strike in Uttarakhand, which was held to be illegal, and the Supreme Court upheld the High Court's decision to initiate disciplinary action against the Bar Association. Notices were issued to the Bar Councils for further regulatory actions. Now, PLR Projects versus Mahanadi Coalfields Limited. This was another case where mass boycott for a separate High Court bench was termed as gross misconduct. The Supreme Court prompted suspension of 43 advocates' licenses by the Bar Council of India in this case. So Praveen Pandey versus State of MP. This is 2018 SCC Online MP 281. In this case, Madhya Pradesh High Court declared a State Bar Council-led week-long strike over administrative demands as illegal and unconstitutional, applying the principle in the case of Harishupal. Scurrilous allegations against courts or registry. These have also been held to be unbecoming conduct. One case in this line is Reepak Kansal versus Secretary General of Supreme Court, 2027 SCC, page 805. The court held that registry is equivalent arm of the court, so casting aspersions is unbecoming conduct. Then Vijay Kurle, suo motu contempt petition. This is another case where baseless public allegations were held to be contempt. This is 2021, volume 1, SCC 745. Now, the next subtopic is advertising and soliciting work. Now, the relevant rules here are Chapter 2, Part 6 of the BCI rules. This prohibits direct or indirect solicitation. AIR 1962 SC 1337, soliciting was held to be a grave misconduct. Bar Council of Maharashtra versus MB Dabolkar, 1976 to SCC 291, where brief snatching and fee undercutting were held to be misconduct. Tata Press Limited versus MTNL, 1995, 5 SCC 139. Commercial speech, although it could be protected under Article 19(1)(a), but advocates are not traders, so therefore this was also something which was looked down upon. Role of amicus curiae. Now, the role of amicus curiae is basically to assist the court or tribunals, as you all know. And these are, amicus curiae is appointed to represent a broader interest, which is not confined to the client, only the client's right. It is basically to sort of generate public confidence in justice. It is, amicus curiae is friend of the court. So it is impartial sort of an approach, which is expected to be put before the court. And normally, legal scholars or senior advocates act as amicus curiae to explain ethical contexts such as conflict of interest, confidentiality, or solicitation. And the idea is that no person should go unrepresented, no accused should be unrepresented. The case is Muhammad Sukur Ali versus State of Assam, 2011, 4 SCC 729. In this case, it was held that the accused cannot be left unrepresented. And then Anokhilal versus State of Madhya Pradesh, 2019, 20 SCC, page 196. In this case, court held that the amicus also requires time for preparation and also for effective assistance. In this case, para 20 also states that right to free legal service is an essential ingredient of reasonable, fair, and just procedure and must be held to be implicit in the rights guaranteed Article 21. So this was another aspect of Anokhilal, apart from holding that the amicus curiae also has to be given reasonable time to prepare. Then Mukesh versus State, 2016, 14 SCC 416. In this case, the court had noted that appointment of an amicus does not imply counsel's incompetency. This only to enrich the enriches the perspectives which are involved in a particular case. So therefore, it doesn't undermine the competence of a counsel. Now, duties of advocate on record. This is I'm moving on to the next subheading, which is name lending has been held to be misconduct. Responsibility is also to the court and not just to the client. Now, AORs are held to be custodian of trust, and their conduct reflects on the trust in the profession, which can be generated by the general public. Now, filing responsibilities of the AORs, the description is must file all pleadings, wakalatnama, and documents honestly and personally. Non-delegation is another aspect of duty of the AOR. Cannot delegate core AOR responsibilities to non-AORs. Then client communication. This is the duty, and the description is must maintain clear, honest communication with clients. Duty to disclose. Must bring relevant facts and precedents to the court's attention, including adverse ones. Integrity. Must avoid conflict of interest, misrepresentation, or misuse of procedural privileges. Now, attorney-client privilege. Relevant law in this regard is Section 126 of the Indian Evidence Act, which covers communication during the course of employment. Now, there are certain exceptions also to this privilege, which says that communication in furtherance of an illegal purpose, if it's not protected by this. Any facts which are observed in criminal acts can be disclosed. Adversarial system, balancing duty to the client and duty to the court. So therefore, this requires a constant ethical balancing act. Public prosecutor and amicus are, it's expected, a higher expectation from them to represent truth and fairness, not just partisan interest. Now, there are 7 labs of advocacy. This is by Justice Abhad Parry. This is 7 lamps which were mentioned by him are honesty. Honesty, the meaning here of the lamp Honesty is truthfulness in facts, law, and representation. Next is courage. So first lamp is honesty. Second lamp is courage, which means speak truth to power, advocate unpopular causes with resolve. Third is industry, which means diligence, preparation, and research. Fourth is wit, which means presence of mind, adaptability in court. Then eloquency, clarity, and persuasiveness in speech and writing. Then judgment, strategic insight, when to push, when to yield. Last is fellowship, which is camaraderie, courtesy to colleagues and the bar. There was another principle, or let's say one more lamp, which was added by Justice Krishna Iyer in his book, which is Professional Conduct and Advocacy, where in 2007, he added another lamp, which was tact. Now, tact refers to a person's ability to handle people and situations skillfully without causing any offense to anyone. In respect of advocates, they are required to be in a position to tackle the case cleverly and tactfully and win it for the client in a smoother way without causing offense to the opposite party. So tact was another lamp which was added in these 7 lamps by Justice Krishna Iyer in 2007. Now, the next topic is key ethical challenges in criminal law advocacy. Now, involvement of a lawyer in criminal law can be on behalf of prosecution, can be on behalf of defense, or even for the complainant. So certain aspects which have to be maintained regardless of the party that is being represented by a lawyer. First is conflict of interest. Criminal defense lawyer must always avoid situations where personal or professional interest conflict with their duty to clients. Representing multiple clients with opposing interests or having personal relationship with parties involved can compromise your impartiality and trust. So therefore, it is essential to disclose and address any potential conflict promptly to maintain the required ethical standards. Confidentiality and attorney-client privilege. Maintaining client confidentiality is a very big cornerstone of legal ethics. However, this duty may conflict with obligations to prevent harm or to uphold justice. In certain situations, such as when a client poses a threat to public safety, lawyers may face ethical dilemmas about whether to breach confidentiality in order to balance their duties. So this requires a very careful judgment if caught in a situation like this. Then upholding the presumption of innocence. Criminal defense attorneys are ethically bound to uphold the presumption of innocence and ensure their client receive a fair trial. This also includes challenging the prosecution's case and presenting favorable evidence, and the advocate concerned must navigate their duty to defend vigorously while respecting the legal principle that a defendant is innocent until proven guilty. Ethical boundaries in aggressive defense strategies. Now, although zealous representation is a lawyer's duty, it must not extend to unethical practice, such as presenting false evidence or misleading the court. Aggressive defense tactics should be employed within the bounds of the law and ethical conduct to preserve the integrity of the process. Access to competent legal representation. In India, this is a very, very fundamental principle. However, the challenges do exist. Sometimes there is inadequate representation by the defense counsel or a counsel which is provided by the legal service authorities. So therefore, it's very important to ensure that all accused individuals have access to proper legal representation, which is very crucial to upholding justice. Now, zealous advocacy involves diligent representation, which means thoroughly preparing our case, including investigating facts and legal precedents, then challenging evidence, questioning the prosecution's evidence and presenting alternative interpretations, protecting clients' rights, ensuring that the client's rights are upheld throughout the legal process, and truthfulness, of course. The attorney must not present false evidence or make false statements before the court. Fairness and integrity are other aspects of legal practice which need to be maintained, particularly when you're representing a client in a criminal case. Now, ethical challenges are faced by a defense lawyer. Sometimes one can be representing the guilty. Defense attorney often represent clients who may be guilty of the charges against them. While the presumption of innocence is a fundamental principle, attorney must navigate the ethical dilemma. This includes ensuring that the clients receive a fair trial and the legal process is not compromised. Aggressive defense strategies are to be employed, but at the same time, they have to be employed within the bounds of law and ethical conduct. Public perception. High-profile criminal cases often attract intense media scrutiny. So defense attorney must also balance their duty to represent their client vigorously with the potential impact on public perception and the justice system. Rahul versus State, which is 2023 1 SCC, page 83, para 42 of this judgment, also mentions about the public perception and how judges and also the lawyers have to be uninfluenced by the public perception and go by the evidence in a particular case. Now, even the prosecutor, ethical challenges in criminal prosecution. Prosecutor also face ethical dilemmas in their pursuit of justice. Now, disclosure of evidence. Prosecutors are obligated to disclose even exculpatory evidence to the defense, and failure to do so undermines fairness of the trial. Now, in Ray Guidelines 2021 10 SCC 598 para 11 and also Manoj versus State of MP 2023 2 SCC 353 para 207 and 208, the court has held that even the evidence which has not been relied upon has to be disclosed to the defense to maintain fairness of the trial. And prosecutor must avoid overcharging, which means that the defendant has to be charged, the accused has to be charged appropriately. Excessive charges should not be pressed upon which could actually lead to unjust outcome. So therefore, for the prosecutor, it is seeking justice, not conviction. The primary goal of the prosecutor is to seek justice and not merely to secure conviction. Reference can be made to Ashok versus State of UP. This is a judgment of 2025, 2 SCC 381. Para 38.2 to 38.4 are the relevant paras. Then comparative study of the legal profession and ethics in various countries. We'll talk about India, United States, United Kingdom, Australia, and France. Very briefly, I'll touch upon this. I guess we're short of time, I think. So in India, the regulatory body is the Bar Council of India, and the law governing the framework and the key ethical principles are Advocates Act 1961, BCI Rules of Professional Conduct, and integrity, dignity, fairness, confidentiality, and avoidance of conflict are the basic ethical principles. And enforcement mechanism is disciplinary committees under BCI at the state level, BCI at the national level, and the disciplinary committees and the bar councils are at the state level. United States, there are state bar associations and American Bar Association and model rules, which are ABA model rules. Now, the governing framework is ABA Model Rules of Professional Conduct. Confidentiality, diligence, competence, loyalty, and conflict avoidance are the main ethical principles. And the enforcement mechanism is state bar disciplinary boards and state supreme courts. Now, United Kingdom is Solicitors Regulation Authority, which is SRA, and Bar Standards Boards, which is BSB. Now, SRA Code of Conduct is the law regulating, and BSB Handbook, and the ethical principles are independence, integrity, duty to client and court transparency. And SRA and BSB disciplinary tribunals and legal ombudsman. These are the authorities regulating the. And in Australia, it is Legal Services Commission, which is state-based, and law societies. And Uniform Law Framework, Australian Solicitors Conduct Rules, and the ethical principles are honesty, condor, loyalty to clients, and fairness. And the bodies are Legal Service Commissioners, Professional Conduct Tribunals. Then France, it is Council National de Barreau. It is, to cut it short, it is CNB, and local bar councils. And it is mostly professional secrecy, which is the paramount importance, and independence, dignity, loyalty, and humanity are the basic principles. And the bodies are local bar councils, court of appeal with supervisory powers. Now, client confidentiality, France holds one of its strictest legal standards under secret professionals. Any breaches on this regard may lead to severe sanctions, including criminal liability. Confidentiality is nearly absolute so far as France is concerned. India emphasizes confidentiality under BCI rules, but permits exceptions in cases involving criminal intent or a client fraud. Section 126 of the Indian Evidence Act can also be referred in this regard. United States, it's a strong duty under ABA rules, with exceptions which are similar to India. United Kingdom, comparable to the US, with nuanced guidance or confidentiality and permissible disclosures. Australia aligns closely with the US-UK model, prioritizes client consent for disclosure, unless overriding legal or ethical obligations are attracted. Then a conflict of interest. United Kingdom and United States both have comprehensive rules detailing types of conflict, which are concurrent, successive, and imputed. Mandatory disclosures and informed consent are mostly emphasized. Australia requires avoidance and disclosure of conflict, particularly in cases of former clients or adverse interests. France is guided by the civil law traditions, places high emphasis on loyalty and impartiality, stricter enforcement due to strong in-house disciplinary tradition. And so far as India is concerned, it addresses conflict through general principles rather than detailed codification. And it certainly has a less robust enforcement. Advertising and solicitation. India traditionally prohibits advertisement. The 2008 BCI amendment allowed limited information on lawyers' website, strict prohibition on direct solicitation. Now, United States permits legal advertising under the First Amendment, provided it is not false, misleading, or deceptive. United Kingdom allows advertising within bounds of professional dignity, must not mislead or exploit clients. These are the criteria laid down. Australia permits under ethical regulations, requires truthful, fair representation, but disclosure can be made. France prohibits direct solicitation, permits limited forms of advertising, such as listing qualification or services under tightly controlled guidelines. Now, duty to the court. the universal principle in all these 5 jurisdictions, the duty to the court is paramount, often taking precedence over client's loyalty. India, UK, Australia, clear hierarchy where the duty to uphold the justice system overrides the client interest in case of a conflict. United States, although adversarial, but ethical rules bind to the court. Now, relevance to the legal profession and bar councils, it generally aims towards maintaining and enhancing professional standards, all these jurisdiction. And now when we talk about cross-border legal practice, the globalization that we look at today demands ethical literacy across legal system. So therefore, there are lawyers engaging in international arbitration, cross-border mergers, litigation, so therefore, multi-jurisdiction compliances are required. So ethical education and continuing professional development, which is CPD. So United States has mandatory continuing legal education. Australia also has compulsory CPD with dedicated hours of ethics. United Kingdom encourages reflective learning and ethical training. So far as India is concerned, it lacks structured CPD as of now. However, there's a growing call in this regard for mandatory ethics modules in both law schools and practice stages. So we could be looking at something like this. So this is the general effect of the foreign models. Now, the last is mediation and conciliation. So the relevant statutes to focus are Civil Procedure Code, Order 10, Rules 1A to 1C. These provisions were introduced to formalize the use of alternate dispute resolution in civil litigation. Order 10, Rule 1A, it empowers the court to direct the parties to opt for one of the ADR mechanisms such as arbitration, conciliation, mediation, or lok adalat after recording admission and denials. Then Order 10, Rule 1B, this permits courts to refer disputes to any of the ADR processes under Section 89 of the Civil Procedure Code. Then Order 10, Rule 1C, it directs parties to appear before the concerned forum or authority once the matter is referred to the ADR. Now, significance of lawyers here, I just briefly touched that. Lawyers must assist the court in identifying cases which are suitable for ADR, that's point 1. And they should also advise clients on the cost effectiveness and timeliness of ADR mechanism. Ethical advocacy now includes a duty to pursue settlement option wherever appropriate. Arbitration and Conciliation Act 1996, Part 3, which are Section 61 to Section 81, which deals specifically with the conciliation, which is a voluntary and confidential form of ADR. Section 65, a conciliator can invite the parties to submit written statements of their position. Section 63, settlement agreement signed under conciliation has the same status and effect as an arbitral award on agreed terms, which makes it binding and enforceable. Section 75 imposes a duty of confidentiality on the conciliator and also on the parties concerned. Advocate's role is again encouraging clients to consider conciliation as a viable alternative to litigation, protect client interest during negotiation while promoting compromise, uphold confidentiality, and avoid adversarial posturing during conciliation. This is the responsibility of the advocates concerned. Then Commercial Codes Act 2016, Section 12A, it's mandatory pre-institution mediation. Then Section 12A(1) says no commercial suit shall be instituted unless the plaintiff exhausts the remedy of pre-institution mediation. Section 12A(2), mediation must be completed within 3 months, which is extendable by 2 months. Then exemption. Implication for lawyers. It's the same thing as lawyers must advise clients of the mandatory nature of mediation before filing suit. Failure to comply may lead to rejection or dismissal of the suit. And so therefore, there is a shift towards ADR and the lawyer's evolving role in this. So India's legal system is definitely undergoing a paradigm shift from adversarial litigation to consensual resolution of dispute. Court and statutes increasingly reflect on a settlement-first philosophy. So therefore, the advocates are no longer expected to merely litigate, but also to act as felicitator of dispute resolution, upholding principle of access to justice and judicial economy. Ethical lawyering now includes promoting peaceful resolution, also not just a legal victory. A lawyer's duty to the client includes advising on ADR avenues wherever suitable, saving time, cost, and relationship. Thank you very much. And thank you very much to SCAORA.
Thank you, ma'am.
And I'm
for a
sorry
wonderful
for
lecture.
having exceeded the time.
No, not at all, ma'am. I'll just start taking the questions. So there are two questions that have been asked. The first has been asked by Chirag Jain, and he says that, ma'am, is there any bar on court order to suspend license to practice under contempt, and such suspension being result of disciplinary proceedings? He's also referred to a case of SCBA versus Union of India.
Yes, we have also referred to that judgment. I had also referred to that judgment earlier, that, you know, there was one case where the license was not suspended. License was not suspended, but however, the court held that if you are hauled up for contempt, then unless the contempt is purged, you cannot practice. You cannot appear before the court. That's what the judgment said.
Right.
So therefore, purging of the contempt,
Okay,
a very important aspect.
right, ma'am. The second question has been asked by Rajesh Kumar, and he has asked that what are the changes in the Advocate Amendment Bill, and should we know this for the upcoming exam in 2025?
Actually, what did you say? What
Yes, ma'am.
question
He
was that?
basically asked that what can be the recommended changes in the Advocate Amendment Bill, and should we know this, and should we mention this in the upcoming AOR examination? Do you think it will come in the exam?
The changes which are proposed in the 2025 amendment are basically, there are originally there was opposition when the Indian stakeholders were sort of prompted to revisit the entire issue when the foreign practitioners were allowed. So now there are changes under the 2025 Act, which one is that the scope of practice is clarified. For foreign lawyers, they say that they may represent clients with principal offices abroad in international arbitrations in India, and they have also defined the fly-in and fly-out regime. So as per the syllabus, which the proposed topics which have been given in the notice, I didn't really see the relevance of this. But if that's the reason I didn't sort of even touch it, because I didn't see the relevance. But if any question comes which you feel requires, then maybe you can just have a brief look at it, and if required, it just one thing, I don't know if I'm exceeding my
No, not at all, ma'am.
my brief.
The pleasure.
When you write an answer, the rule which I followed was that when you write an answer, you must always break it in headings and put the headings in the bold, and so that when your paper is being checked, so the heading should indicate that you know what you're writing. So sometimes the examiner have tendency of skipping the contents under the heading. Heading should give an impression that you know what you're writing. And what I had done was, I had seen the 10 years question papers, and I saw a trend that there were some broad topics which were being asked every year. So I went by the trend and I saw the frequency. I checked out the frequency as to, how frequently each topic is being asked questions upon. So then going by that frequency, I picked out the topics that these are topics which are likely to be taken up in the year when I had appeared. So maybe this is worth
This is a hack
exercise.
for the exam.
Yeah. So one is, break your answers in headings and put headings in bold more prominently.
Right.
And the second is you may want to check the frequency of the topic based on the 10-year question papers, and it may help. I'm not sure whether it will, but it may.
No, ma'am, I think that's the most important, hack that you've given to clear this exam. Because even my seniors gave this hint to me. And I'll just conclude, ma'am, with the vote of thanks to you. I, on behalf of the Supreme Court Advocate on Record Association Executive Committee, I extend our heartfelt gratitude to you, ma'am, for delivering on the insightful lecture on professional ethics as a part of the SCAORA AOR lecture series. Your expertise in highlighting the key principles such as integrity, accountability, confidentiality, fairness, respect, and explaining the professional misconduct, 7 lamps of advocacy and strikes has been invaluable. Ma'am, you are providing with an in-depth knowledge, and since you cleared this exam almost 2 decades ago in 2004, I think your in-depth analysis will definitely help the AOR aspirants and provide them with a first-hand understanding of what the importance of upholding ethical standards in the profession really means. We appreciate your presence, ma'am, on a Sunday evening in this lovely weather, and we look forward to having you again on board for the future SCAORA AOR lecture series. Thank you for everyone who's attended this lecture, and we wish everyone the very best of luck for the exam. Thank you so much, ma'am.
Thank you very much. Thank you, Meenakshi. Thank you very much. Thanks, Nikhil. Thanks, Reena. And thank you, everyone.